Honor. We're here in the matter of the State of Ohio versus Matthew Barrett, case number 25 CR 000273. We are set today for a probable cause hearing on the state's motions to terminate intervention in lieu of conviction filed on September 19th. The defendant is present in open court with their attorney, John Fertiga.
Thank you. Mr. Fertiga, what's the defendant's intention at this time regarding his right to a probable cause hearing?
Good afternoon, Your Honor. I discussed this matter with Mr. Barrett. I believe he's going to waive his probable cause hearing and final hearing like to resolve the violation this afternoon.
Thank you. Mr. Barrett, you've been charged with violating the conditions of your community control sanctions. Specifically, there are two alleged violations. The first is a violation of Rule 11, which requires you to comply with all special conditions set forth by the court. And special condition number 2 ordered that upon your release from jail, that you enter and successfully complete the Department of Veteran Affairs treatment program at Stella Maris Residential Treatment Facility and follow all of their recommendations. And it's alleged on September 14th of this year, you moved out of Stella Maris prior to completing the treatment program. The next allegation is a violation of Rule 8, which prohibits anyone on probation from using, possessing, or having under their control any controlled substance that's not prescribed to them by a licensed physician, and the use of alcohol is also prohibited. And it's alleged on September 15th you reported that you consumed alcohol on September 14th. Now you have the right to have actually 2 hearings regarding these allegations. The first is called a probable cause hearing. And that's a hearing where the state would be required to present some evidence that would suggest the person probably committed a criminal offense, committed this violation. The second hearing would be on another day and time to give you time to prepare if that's what you wanted. And that's a final hearing on the merits where the state would be required to present the actual merits, prove the actual merits of what they're alleging. Now you could have either or both of these hearings, but you can also waive the hearing and admit to the violations, and your attorney has indicated he believes that's what you want to do, waive the hearings and admit to the violation. Is that correct?
Yes, Your Honor.
Well, before I can accept your waiver and your admission, I need to make sure you understand the potential consequences you face if you are found to be in violation of the intervention plan that was ordered by this court. If in fact that should occur, the court would vacate the stay of criminal proceedings that was ordered back on May 5th of this year. I will find you guilty of the 3 charges that you pled guilty to, and we'll then proceed to sentencing, where a prison term of 6 to 12 months could be imposed on each count. Those could be run consecutive to each other for 3 years in prison. There could be a fine on each count of $2,500 for an overall maximum fine of $7,500. I could suspend your driver's license up to 5 years. I could also, instead of prison, put you on probation with an order that you serve time in our county jail and with whatever other conditions or programs I deem to be warranted. You understand the potential penalties and the consequences you find and you face if you are found to be in violation of this intervention plan?
Yes, Your Honor. What
that also means, with the intervention of conviction being terminated, that this will now be a conviction, and it will be a conviction on your record. You understand that?
Yes, Your Honor.
And well, having been advised the consequences of being found to be in violation of the intervention plan, what would you like to do at this time? Do you want to have either the hearings, or do you want to waive the hearings and plead guilty to the violations?
Waive and plead guilty.
I would like to waive the hearing and plead guilty, Your Honor.
Very well. As to the allegation that you violated Rule 8 by drinking alcohol, what is your plea to that?
Guilty, Your Honor.
As to the allegation that you violated Rule 11, Condition 2, by leaving Stella Maris prior to successfully completing the program, what is your plea to that?
Guilty, Your Honor.
All right, the court will accept your pleas of guilty, find that you did violate. At this time, based on that, the court is going to vacate the stay of criminal proceedings that was imposed by or ordered by this court previously. I'm going to find the defendant guilty of count 1, possession of cocaine, a felony of the 5th degree in violation of 292511 of the revised code, and counts 2 and 3, each offense of aggravated possession of drugs, each felonies of the 5th degree in violation of 292511 of the revised code. The court previously completed a pre-sentence report. I'll incorporate that at this time. Mr. Fatika, any reason not to proceed to sentencing?
No, Your Honor.
Is there anything you want to say on behalf of your client?
I would, Your Honor. Good afternoon. I've had an opportunity to review the pre-sentence report from May of this year. As the court's aware, Mr. Baird is an honorably discharged Army veteran. He made it through 4 months of the treatment at Stella Maris. He was right at the end with 1 or 2 classes to go before these allegations arose. He's been cooperative throughout, no other issues other than the violations that you see in front of you. He's worked as a mechanic in the past. He's very employable. We ask that you consider all of those factors in considering a penalty.
Mr. Barrett, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. First, I would like to apologize to you and the courts for not completing and complying with the first special conditions and also consuming alcohol. And I would like to thank you for the opportunity for the in lieu of conviction treatment in lieu of conviction program. And furthermore, I fell short. I overworked myself, and
Why'd you leave?
I wanted to be home with my family and had every intention of finishing the class, but just didn't get there.
What do you mean you had every intention of finishing the class?
I had 1 class left on that week of the 15th on Thursday, and Saturday I went to work, stayed the weekend with my children, and didn't go back to Stella Maris Sunday evening, and then went to work Monday morning to find that one small mistake had cost me everything.
Anything else you want to say?
Is there anything else you want to say?
No, Your Honor, that's all.
Mr. Fatika, anything else?
No, thank you, Your Honor.
The state of Ohio, Mr. Knopf?
Yes, Your Honor. The state would recommend community control. The state does want to point out that the defendant did violate his bond previously while during the course of this case he did pick up new charges. However, due to the conduct of this case that he's here for today, the state would recommend community control.
What was the bond revocation for? It looks like it was probably done in Muni Court, maybe, if I'm looking at this right.
I don't believe his bond was revoked in our case. I can't recall if it was or not. I just know when we got the PSI.
You said there was a violation of his bond.
He picked up a new charge while he was on bond in our case that I don't believe that we knew about.
Well, his bond was revoked. I mean, the arraignment, it says bond remains revoked. I don't know. Let's see. There was a motion to reinstate the bond on March 9th. That was filed. That was denied. So. That's what I thought you were referring to when you said he violated his bond.
Yeah, I apologize, Your Honor. I maybe got mixed up with a different case. I just remember us at sentencing.
Oh, he failed to appear in it early on.
Yeah. I remember us having the conversation in Chambers prior to sentencing that he had new cases.
He failed to appear for his preliminary hearing. Well, this court has reviewed and considered pre-sentence report and investigation that was completed, drug and alcohol evaluation, intervention report that was done initially. I've considered the facts and circumstances of the original offense involved, the nature of that offense. Considered the defendant's performance under the intervention plan, the nature of the violation of the intervention plan. I've also considered everything that's been said here today by the defendant himself, prosecutor, Mr. Fatika, on behalf of his client. All this is considered only the purposes and principles of felony sentencing set forth in 29.29.11 of the revised code. So the factors in 29.29.12, nothing stands out factually, indicating it's more or less serious than the normal conduct that constitutes the commission of these offenses. As for recidivism factors, court notes the defendant does have a history of criminal convictions, goes back about 8 years. Court notes that the defendant was on bond on a domestic violence charge, awaiting sentencing when he committed this offense. He violated his bond by failing to appear in court for a hearing on this case. And then he also picked up a new offense while he was on while he was on bond at this court for this case. Despite all that, I still gave him a chance with intervention in lieu of conviction. And we're back here less than 4 months later. Or 4 months later, I should say, not less than 4 months later. Defendants failed to comply with the previously imposed sanctions ordered by the court. No factors indicate recidivism is less likely. Under 29.29.13b1, again, the court notes the defendant was on bond at the time he committed the offense, which overrides the presumption for probation, permits the court to impose a prison sentence without having to make any findings in that regard. Despite that presumption being overcome, the court does find at this time that prison would not be consistent with the purposes and principles of sentencing. And the defendant is amenable to available community control sanctions. Therefore, it will be the sentence of this court that the defendant be placed on community control sanctions for a period of 2 years starting today. As conditions of his community control sanctions, he be ordered to serve 56 days in the Lake County Jail. He has credit for 11 he's already served. He is to, the last 45 days, enter and successfully complete the jail treatment program, follow all their aftercare recommendations, including recommendations for AA meetings, whatever they recommend for AA meetings, if any. That will be a condition of your probation that you need to do that. I also want you to complete the Decision Points program, which you'll be able to start while you're in the jail, and may not finish it, but you can finish that once you're done with your sentence. Further conditions, you're not to use any drugs or alcohol. You must submit random urine screens. They have to be negative. Positive screens a violation. You're to obtain and maintain full-time employment. Obtain a mental health evaluation. Follow their recommendations for any type of counseling, if any. 1 doctor, 1 dentist, 1 pharmacy. Sign whatever releases are necessary for probation to speak with these doctors if it's needed. Pay court costs and supervision fees. Jennifer, anything else I should be considering here?
No, thank you, Your Honor.
Mr. Barrett, you understand all the conditions of your probation?
Yes, Your Honor.
Any questions for me?
You have to answer out loud.
No, Your Honor.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from this court, or if you commit another offense while you're on probation, a motion to terminate your community control sanctions will be filed. If it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions against you, including an order you serve local jail time, or I could terminate your probation and send you to prison. If I did that, it'd be 12 months on each count consecutive for an overall total of 3 years in prison, and that would be consecutive to any other sentence you may be serving at that time or that you're being sentenced to at that time. You also need to make sure that you keep probation advised of where you are residing. Prior to this, you were living out of your car, is what you told us when
Yes,
this
Your Honor.
first happened. Now it sounds like you're back with your girlfriend, who at the time you said was an on-again, off-again type of thing. So I'm guessing you're on again now.
Yes, Your Honor.
If it goes off again, you need to let them know where you're living. If
Yes,
it
Your Honor.
turns out that you're somewhere else other than where they know, that's a violation. You understand that? That's a rule of probation, so you'd be violated for that.
Yes, Your Honor.
All right. And it doesn't matter where it is, if they need to know about it. I mean, if
Yes,
it's out of the county, I guess this address is in Euclid, but if it's somewhere other than Cuyahoga or Lake County, they need to be told that.
Yes, Your Honor.
Is that accurate? Okay. All right. Mr. Knopf, anything else for the record?
No, Your Honor.
Mr. Patika?
No, thank you, Your Honor.
is present in open court with their attorney, Jim Matthews. We are set today for a change of plea hearing where the defendant will be pleading to an amended count 1, attempted tampering with evidence, a felony of the 4th degree, and count 3, possession of a fentanyl-related compound, a felony of the 5th degree. There is no agreement regarding sentencing. The state would request a pre-sentence report and a drug and alcohol assessment prior sentencing.
Thank you. Mr. Matthews, does that sound correct?
Yes, Your Honor.
And Mr. Graff, were you able to hear what the prosecutor had to say regarding what he believes your plans are here this afternoon?
Yes, Your Honor.
He indicated to the court he believes that your desire to withdraw your previously entered pleas of not guilty and enter a plea of guilty to a couple charges here, and I'll go over those with you to make sure you understand exactly what those charges are. We would then dismiss the balance of the indictment, defer sentencing to a future day to get some reports completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right and fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and most importantly, what you want to do here today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. You need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor. Thank you.
All right, give me 1 second here. All right, let's get started. How old are you, sir?
I am 37.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
No, Your Honor.
Now, did you receive a copy of the indictment in this case? That's the document that sets forth the specific charges you're accused of committing. It looks like you should have gotten that sometime around middle to end of July. Do you know getting that?
Yes, Your Honor.
And did you have the chance to look that over?
Yes.
Is this open? Hang on a second. Now, in that indictment, you are charged with 3 counts. You're pleading guilty to 2 charges. Count 1, what you're charged with, this isn't what you're pleading guilty to. What you're charged with, and what's alleged here, is on or about April 29, 2025 in Lake County, Ohio, that you, knowing official proceeding or investigation was in progress or was about to be or likely to be instituted, that you altered, destroyed, concealed, removed any record, document, or thing with the purpose to impair its value or availability as evidence in the proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the 3rd degree. Now, that's what you're charged with. That's not what you're pleading guilty to. That's what you're charged with. Do you understand what you're charged with?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Your paperwork says forfeiture specification. I don't see a forfeiture specification in count 1.
There's not, Your Honor. I spoke with Mr. Matthews right beforehand. There is no forfeiture on count 1.
Now, for purposes of the plea, the state has agreed to amend this count to what's called attempted tampering with evidence. And what that means is that it alleges that you engaged in conduct that, if successful, would result in the offense that I just read to you. The bigger significance is that it reduces it from a felony of the 3rd degree to a felony of the 4th degree, which is Actually, a lot less serious here in Ohio, the difference between those two. So it's a less serious offense. Still a felony, obviously, and serious, but it's not as serious as felony of third degree. So do you understand the difference between the two?
Yes, Your Honor.
Any questions for me?
No, Your Honor.
Now, on count 3, what's alleged here and what you're admitting to is on or about April 29, 2025 in Lake County, Ohio, that you did knowingly obtain, possess, or use a fentanyl-related compound or a mixture, preparation, or substance containing a fentanyl-related compound. It's further alleged the amount involved did not equal or exceed 1 gram, which makes the offense possession of a fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in count 3?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, this charge does carry a forfeiture specification, which alleges during the commission of the offense you possess or had an interest in property considered to be contraband or an instrumentality. Contraband is property that is illegal just because of the nature of the property itself, like drugs. An instrumentality is some type of property that there may not be anything illegal about the property in and of itself, but it's being used in an illegal manner or to facilitate a crime, and you can't use or possess it for that purpose. So here it's alleged that fentanyl-related compound is contraband along with packaging that was found and confiscated as instrumentalities. You understand what, you have any questions about that? The whole point of this is that you forfeit any ownership interest you have in it. It doesn't increase any potential penalty you face, but it's the way that the prosecutor's office needs to go about to be able to destroy that property ultimately.
I understand, Your Honor.
Okay, any questions?
No, sir.
All right, now there's a second count of this indictment that's being dismissed pursuant to the agreement. Is that your understanding?
Yes.
Any questions?
No.
Well, before I can accept your guilty plea, then I need to make sure you understand all the rights you are giving up. And you, first of all, do have the right to have a trial with these charges, and that could be to me as a judge, or I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to a jury trial, and that will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence, and then those jurors will make that ultimate decision. And that ultimate decision reached by those 12 jurors would have to be unanimous. What that means is all 12 of them would have to agree together, one way or the other, as to each charge, whether you're guilty or not guilty. You understand that?
Yes, Your Honor.
You understand by pleading guilty you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we did have a trial, prosecutor here would be representing the state of Ohio, and he would have what we refer to as the burden of proof. Now, by him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of these charges, and that presumption of innocence stays with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state has presented at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would be bringing witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right, at a trial, you can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
You further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
You understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? So it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the fourth degree in this reduced charge for count one. This felony of the fourth degree is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, count three is a felony of the fifth degree. This offense carries with it a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, since these are two separate charges here, if I impose a prison term, I would impose it on each count. And as the judge, then I would have the discretion to run those prison terms concurrent or consecutive to each other. Concurrent means together. You serve them at the same time. Consecutive is the opposite, one after the other. You serve the prison term on the first count, finish that, then the prison term on the next count. So you understand the difference there?
Yes, Your Honor.
So in this particular case, if I impose the maximum sentence and ran the prison terms consecutive to each other, you're looking at a maximum possible prison term of 30 months, or 2.5 years in prison. You understand that?
Yes, Your Honor.
Now, are you currently on probation or community control, post-release control, any type of supervision or any other courts or agencies?
Yes, Your Honor.
You're in PRC?
Yes.
Now, you were just put on PRC, though, right? Just a couple months ago?
Yes, Your Honor.
So you were not on PRC when this happened?
Correct.
Were you on any type of supervision when this happened?
I was on probation.
And is that why you went to prison?
Yes, Your Honor.
Because you committed a new charge or something else?
Yes, it was.
The reason I'm asking this, and it sounds like maybe something's already happened, but if you're on probation to another court and you commit a new felony, there could be consequences in that court as a result of committing a new felony while you're on probation.
Yes, Your Honor.
Nothing I could do about it, but there could have been consequences, and maybe there were already. Is that what happened?
Yeah.
That's why you went to prison
Yes.
in the July or so?
Yes, Your Honor.
You pretty much got credit for time served, right?
Yes.
Okay. So it doesn't sound like there'll be any other consequences because they already did it. You have any other charges pending against you anywhere right now?
Yes.
Where's that?
Willowick.
Is it felony or misdemeanor?
It's felony.
Felony.
Okay, so it's going to be coming over?
Yes.
It's already, it's over.
Okay. Well, I need to advise you that if at the time of sentencing, you've already been sentenced to prison in another case, or you're being sentenced at the same time on this other case, if I impose a prison sentence in this case, I can run it concurrent or consecutive to that new case. Now, I can only do that if either they're being sentenced at the same time, or you've already been sentenced to prison. I can't order this prison term, if it was a prison sentence, to be consecutive to some future possible unknown sentence. So you either have to be getting sentenced at the same time or already been sentenced to prison in order for me to do that. Do you understand that?
Yes, Your Honor.
Okay. Now, if a prison term is imposed in this case upon your release from prison, you could be placed on what is called post-release control for this case, sometimes referred to as parole. Again, as you know, it's a period of supervision you would be on after you serve the prison sentence. With this particular charges, it could be up to 2 years, though it's not for me to decide that, it's the parole authority. If you are put on post-release control and you violate any of the conditions, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there are other sanctions that could be ordered. You could be fined, in this case, up to $5,000 on count 1, the lesser charge of count 1. Another $2,500 on count 3 for an overall maximum possible fine of $7,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
There's also, for the drug charge, a possible license suspension of up to 5 years that I could order. Do you understand that?
Yes, Your Honor.
And again, as for that forfeiture specification, any right, title, or interest you have in that property will be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
All right, now a few moments ago I explained the possible prison sentence. I used the word possible. Prison's not mandatory or required with these charges. You are eligible for probation or what is called community control sanctions. Do you understand that?
Yes, Your Honor.
You understand that just because you're eligible for probation doesn't mean you automatically get probation. It means I'll consider that if that's what you're asking for. I'm going to look at all the information that gets presented to the court. Then I'll make the decision that I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, Your Honor.
Further, if you are put on probation of the court and you violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years. It wasn't originally 5 years. I could impose more restrictive sanctions against you, including an order that you serve time in the county jail, or I could terminate your probation at that point and send you to prison then. And if I did it at that point, again, it could be the period of time, or ultimately up to 30 months in prison, and that could be consecutive to any other case you may be serving at that time or that you're being sentenced for at that time. You understand that?
Yes, Your Honor.
All right, lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
May I talk to my lawyer for a second?
Sure, go ahead.
When I was in prison, I filed a motion of availability of result that's all in there. So you mentioned I think because you mentioned that the pretty rank and that's what I was trying to get what I wanted. I was trying to get everything resolved.
How long were you actually in prison?
Well, it was supposed to be around 100 days, but now it's around 50.
They have 180 days. Thank you, Your Honor.
Thank you, Your
You're
Honor.
welcome. Any questions for me at all?
No, Your Honor.
So I'm not exactly sure where I left off, so I'm just going to maybe backtrack a second here. So you understand all the penalties. You still want to plead guilty?
Yes, Your Honor.
Okay. Have you had enough time now to talk with your lawyer about the case and have him answer all your questions?
Yes,
Are
Your
you
Honor.
satisfied with his advice and counsel?
Yes, thank you, Your Honor.
It's all right. Has he or anyone else made any promises to you regarding what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering this guilty plea freely and voluntarily?
Yes.
All right then, Mr. Graff, do you have any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to speak with Mr. Matthews before we go forward with your plea?
No, Your Honor. Thank you.
All right, then what's going to happen at this point is the prosecutor here will make or will advise me of what he believes the evidence would show if we had a trial. I want you to listen to him because then I got some questions for you about that, all right?
Yes, Your Honor.
All right. Mr. Knopf.
Thank you, Your Honor. Had the case proceeded, the trial, the state would have shown that on or about April 29th, 2025, the defendant was a passenger in a motor vehicle that was stopped due to a flock camera hit. The vehicle was registered as unauthorized use. Officers stopped the vehicle, and while the K-9 unit came and did a free air sniff around the vehicle and alerted to something inside of the vehicle, the defendant was pulled out of the vehicle. At that time, he admitted to throwing a bag on the ground in an attempt to conceal it from the police. That bag was sent to the Lake County Crime Lab and confirmed to be fentanyl amongst the other drugs inside of that bag.
So, Mr. Graff, were you able to hear what the prosecutor had to say regarding what he believes the evidence in this case would show if we did, in fact, have a trial?
Yes, Your Honor.
And what, if anything, do you have to say about those facts that he just presented them? Are they true? Did you do what he said?
Yes, Your Honor.
Very well, then, regarding the lesser included offense of count 1, charging with attempted tampering with evidence, a felony of the 4th degree, what is your plea to that count?
Guilty, Your Honor.
Regarding count 3, charging with possession of a fentanyl-related compound, a felony of the 5th degree with the forfeiture specification, what is your plea to that?
Guilty, Your Honor.
Okay. I have in my possession at this time a document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this document, what it says, and that you sign it here in court. Now, my understanding is that before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Matthews, is that accurate? Did you review this with Mr. Graff, read it over with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you?
He did.
Is that correct, Mr. Graff?
Yes,
Do
Your
you
Honor.
understand what the document says?
Yes, Your Honor.
Do you have any questions for me about it?
No, Your Honor.
Now, it also appears that you signed it. Did you sign it?
Yes, Your Honor.
You witnessed that, Mr. Matthews?
Yes, Your Honor.
Mr. Knopf, you as well?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights. He made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, finding the defendant guilty of the lesser included offense of count 1, attempted tampering with evidence, and felony of the 4th degree in violation of 2923.02 and 2921.12A1. I will also find the defendant guilty of count 3, possession of a fentanyl-related compound, and felony of the 5th degree in violation of 2925.11 of the revised code with the forfeiture specification. I will dismiss count 2 at the time of sentencing, but I'm going to defer sentencing, order a pre-sentence report and investigation, drug and alcohol evaluation. I'll continue bond at $5,000 cash surety. So what all this means, Mr. Graff, as far as bond goes, I'm not changing that at all. You posted your bond. That'll be continued. And one of the conditions that you don't use drugs or alcohol, you have to submit urine screens. If requested, they have to be negative. Positive screen would result in your bond being revoked and a warrant being issued for your arrest. You understand that?
Yes, Your Honor.
Also, in order for me to even consider probation as an option, this pre-sentence report has to be completed. In order for that report to be completed, the interview with you must take place. So it's important you show up when you're supposed to, on time, to meet with the probation department, because if they're not able to interview you because of your lack of cooperation and that you didn't show up, then they won't be able to complete a report. And without a report, the law doesn't even allow me to consider probation as an option. And I won't continue the sentencing to a future day to get the report done because it wasn't completed initially because you didn't show up. You understand that?
Yes, Your Honor.
You sure? Or were you?
You said I didn't show up?
If you didn't show up.
Oh,
I'm saying
I'm sorry.
if they didn't get a report done because they couldn't interview you because you didn't show up,
Okay.
then I'm not going to continue the sentencing to a later day to get that done if that's the reason, because you just didn't show up and that's the reason they couldn't do it.
Okay. Thank you, Your Honor.
You understand that?
Yes.
All right. All right, so you're going to leave here right now. You're going to go over to the probation department. You're going to meet with them, fill out some initial paperwork, and get your dates to come back. So make sure you do that when you leave here.
Okay. Thank
All
you, Your
right.
Honor.
All right, Mr. Matthews, anything else?
No, Your Honor, thank you.
Mr. Knopf?
No, Your Honor, thank you.
All right, thank you all.